Government information belongs to the citizens whose tax dollars paid for it and whose vote gave the government permission to create it, and it shouldn't be like pulling teeth to get hold of it. Mr. Speaker, sunlight is a powerful disinfectant, and freedom of information is the oxygen democracy breathes. The public has a right to know what their government is doing, and secrecy is the natural enemy of good public administration. These simple principles are the foundation of our access to information laws and the principles that this private member's bill seeks to strengthen and uphold. It's the culture of secrecy that allows corruption to flourish and for maladministration and abuse of power to occur in government. Indeed, the seeds of corruption are planted in the dark. And while I agree with the great American jurist Oliver Wendell Holmes when he said that you can't legislate morality or enforce ethical conduct, there is no doubt in my mind that observation and scrutiny has the natural effect of elevating the standards of ethical behavior and of curbing maladministration and abuse of power. Sunlight, Mr. Speaker, again, is a powerful disinfectant. Being forced to operate in the light of day lifts the performance and raises the bar of good public administration. Being forced to operate in the light of day lifts the performance and raises the bar of good public administration. Openness and transparency leads to greater care, frugality, integrity, and honesty. And secrecy diminishes performance in all of those categories. As former Information Commissioner John Reid put it, all the checks and balances designed to limit abuses of government power are dependent upon there being free access by outsiders to government's insider information. But that notion of government's insider information speaks to the very root of the problem. The information doesn't belong to the government or the bureaucracies or the public servants who created it. It belongs to the people. Government information belongs to the citizens whose tax dollars paid for it and whose vote gave the government permission to create it, and it shouldn't be like pulling teeth to get hold of it. And surely parliamentarians who are trying to get information from the government so they can effectively do their jobs on behalf of the people who elect them shouldn't be treated as outsiders trying to get our hands on insider information, yet increasingly that is the situation we find ourselves in. So while successive Canadian governments have paid lip service to the notions of transparency and accountability to the point where they have become almost meaningless buzzwords in this country, very few have shown any real commitment to open government beyond the bare minimum required to maintain the illusion. In the words of former Auditor General Denis Desautel, there is a reluctance to let Parliament and the public know how public programs are working because you may be giving your opponents the stick to beat you with. And even if the minister is not personally concerned with this, senior public servants assume this fear on the minister's behalf. They try to give out as little as possible that would ever expose their department to any criticism. This private member's bill, Mr. Speaker, does not pretend to be a comprehensive rewrite of the access to information legislation, nor does it pretend to fix or correct all of its shortcomings. Instead, Bill C-567 is a modest effort and seeks to address only those aspects of reform on which there is a stated and documented consensus. Colleagues on the government benches will recognize all 6 elements of Bill C-567 as they are taken chapter and verse directly out of the Conservative Party election platform. In fact, there is nothing in my bill that is not taken word for word from the election promises that the present Conservative government made to Canadians. 6 simple points. Number 1, giving the Information Commissioner order-making powers to compel the release of information that he or she determines should be released. Members will find this in Section 5 of my bill. Point number 2, expand the coverage of the Act to all Crown corporations, officers of Parliament, foundations, and organizations that spend taxpayers' money or perform public functions. You will find that in Section 9 of the bill. Point 3, subject the exclusions of Cabinet confidences to the review of the Information Commissioner, Section 3 of my bill. Point number 4, oblige public officials and direct or require them to create documents and to retain the records necessary to document their actions or decisions, Section 2.1. Point number 5, provide a general public interest override for all exemptions so that the public interest is put before the secrecy of the government. And the final point, number 6, to ensure that all exemptions from the disclosure of government information are justified only on the basis of harm or injury that would result from the disclosure, not blanket exemption rules. Mr. Speaker, today's Access to Information Act is terribly outdated and dysfunctional. It is broken and in desperate need of repair. The current Information Commissioner in her October 2013 report stated there are unmistakable signs of significant deterioration in the federal access system. The Conservatives agreed when they were running for office that all of the changes suggested in Bill C-567 are desirable and necessary if we are to make manifest the lofty principles of freedom of information and the people's right to know. They promised the Canadian people that if elected, they would implement the 6 specific changes to the Access Information Act found in Bill C-567, and today I hold them at their word. Thank you, Mr. Speaker.
Well done.
Let me turn this House to an important feature of Bill 567, which is also problematic. It appears in Clause 3. Clause 3 of the bill would modify the current exemption that the government institutions can use to protect records relating to operations of government. I believe it is important to draw the House's attention to the fact that the exemption currently in the Access to Information Act that can be used to protect advice prepared for government is what is referred to as a discretionary exemption. This means that the head of government institution must first decide whether a particular record contains the advice prepared for government. Next, the head must decide whether to exercise the discretion by way of protecting the record or by way of releasing the record. This seems to me to be a fair approach. This exemption is an important one. It is used to protect the advice and recommendations that the public servants give to a minister, or advice or recommendations that may be coming from a minister. The exemption is also used to protect the confidential deliberations taking place within the public service on policy options. The rationale behind this exemption is that disclosure can, at times, have a chilling effect on the candidness of advice, recommendations, consultations, and deliberations given or received by a federal public service, and can lead to their reluctance to deal frankly with a difficult situation. The modification proposed by Bill 567 required the government institutions conclude that the disclosure of a record is harmful to their operations and their processes before they decide to refuse to disclose their record. I wonder how that is workable. How would it be for the government institution to have a genuine reason to protect, at least temporarily, advice prepared for government to be able to demonstrate that the release of the advice would be harmful to their operations? I would also add that the bill would not only add this prejudice test, it would also shorten the time period of application of this exemption to 5 years instead of 20. So, if I understand correctly, after 5 years, this exemption would no longer be applicable by a government institution to protect the public policy advice given to a minister. Now let me turn to another provision of C-567. Clause 4 constitutes a crucial aspect of this bill. As a result, Clause 4, the bill would considerably modify the way that confidences of the Queen's Privy Council for Canada have been treated under the Access to Information for the past 30 years. We can all agree with the Supreme Court of Canada when it said that cabinet confidentiality is essential to good government. Babcock versus the Queen, 202 SCC 557 in paragraph 15. Mr. Speaker, there exists in Canada a constitutional convention wherein private deliberations between ministers of the Crown for the purpose of rendering advice to Her Majesty should remain confidential. This constitutional convention has been recognized in 3 statutes: the Access to Information Act, the Privacy Act, and the Canada Evidence Act. In his proposed reform to the Access to Information Act, former Information Commissioner Reid did not recommend that the role of the Information Commissioner be changed in any such way. Mr. Reid's view was that the Ombudsman would work effectively, that fewer than 1% of complaints end up in courts, and that based on experience in other jurisdictions, the order-making model would not reduce litigation or improve outcomes. His predecessor, the late John Grace, also voiced similar views during his mandate. This bill also contains a requirement that the head of a government institution disclose a record if the public interest in disclosure clearly outweighs the need to maintain the secrecy of the information, even if an exemption would otherwise apply. What this means exactly is not clear to me, and what guidance could be given to the government institutions on this matter is also equally unclear. Mr. Speaker, I submit that what members of this House would need to think very carefully about is the impact that such a public interest override test would have on the application of certain very important exemptions in the Access to Information Act. Most notable is the one which relates to information obtained in confidence from our international allies or provincial counterparts. This exemption, which is mandatory for very good reasons, would, under Bill C-567, be subject to a public interest override test. What would this mean? What greater public interest could justify the disclosure of records provided to us in confidence by another government? How would we explain that documents that we receive in confidence from our international or provincial counterparts may not necessarily remain protected? These are serious concerns. The same public interest test would apply to the exemption protecting personal information. We all know that personal information about an individual is protected under the Privacy Act. The courts have recognized that the Access to Information Act and the Privacy Act are two-sided coins. Together, they set the rules governing disclosure and protection of information held by the federal government. They are equally important statutes, and when applying them, judges must read them together. The Supreme Court of Canada said that the Access to Information Act and the Privacy Act are a seamless code with complementary provisions that can and should be interpreted harmoniously. There are provisions in the Access to Information Act that allow for personal information to be disclosed in very specific circumstances and is instructed by the court. These provisions are carefully drafted to work harmoniously with the Privacy Act. This means that more personal information cannot be disclosed under the Access to Information Act than would be authorized under the Privacy Act. Both statutes regulate the disclosure of personal information to third parties in the same way. I think it is important to note that what is being proposed could be very damaging to the privacy interests, Mr. Speaker. As no doubt we realize the federal government relies on Canadians' willingness to provide the government with their sensitive personal information so that the government can in turn run a myriad of important programs and activities. I would emphasize that in many situations, individuals are actually obliged to provide the government with their personal information. I believe there is a fundamental bargain involved here, which is that because the government requires so much personal information in order to do its business, it bears a heavy burden to take great care with the personal information which Canadians entrust their government. Mr. Speaker, I believe that the introduction of a public interest override in the Access to Information Act requires great consideration. Mr. Speaker, to conclude, I will reiterate the message that the former Minister of Justice, the Honourable Rob Nicholson, gave in 2009 in the government response to the report of the House Standing Committee on Access to Information, Privacy and Ethics, studying the 12 recommendations for reform for Commissioner Lamoureux, where he indicated the following. The Access to Information Act is a strong piece of legislation. It is crucial that careful consideration be given to the impact changes to the legislation may have on the operations to Access to Information program. Legislative amendments must be examined in the context of administrative alternatives, such as enhanced guidance and trainings that can be equally effective to realize continued improvements. Mr. Speaker, I believe that this message is still sound today.
It's important to recognize that Bill 567 has been drafted to include commitments that were actually made by the Conservative Party, this Prime Minister, back in 2006 as a campaign platform, Mr. Speaker. So back in 2006, the current government had recognized deficiencies and the way in which we could actually improve upon those deficiencies back in 2006. And that's why I say through time, I believe that what we are seeing is a stronger drive towards that higher sense of accountability and transparency. So it's only natural, I would suggest to you, Mr. Speaker, that we would in fact want to have further debate, changes to legislation that ultimately is going to ensure more transparency, more accountability on what issues are important to Canadians. Why not recognize that there are public policy that is there, that is very tangible, that Canadians will in fact get behind and support. And I believe that this is one of those pieces of legislation that does have the merit. You know, we have all sorts of annual conferences that take place with different stakeholders. Well, the Commissioner is no different. You know, we have different agencies across this country. Ombudsmen's access to information officers that deal with the delicate issues of privacy and access to information. And it's interesting, Mr. Speaker, that they actually had a conference back in October 2013. And at that conference, information and privacy commissioners and ombudspersons from across the country passed actually a resolution back in October and urged the federal and provincial and territorial governments to update their respective laws. So this is these independent agencies recognizing the deficiencies that are there and challenging legislators, whether you're at the provincial or national level. And here we're talking about a national bill that's been proposed that does have a great deal of merit. One, including myself, would ultimately argue that this legislation, if allowed to get into the committee stage, might be able to address some of the issues in which that conference that took place amongst independents. These are non-partisan, non-apolitical organizations that have been established by different governments of different political stripes, Mr. Speaker. They have recommendations. I would suggest to you that here we have an issue that if it's allowed to continue to be debated, and the best way to do that is to allow the debate here to continue, but after that debate, Mr. Speaker, is hopefully members, in particular of the Conservative Party, will see the merit in terms of allowing the bill to go to committee, where we can have a more wholesome, full discussion on what is an important issue for all of us.